Who's next?
Your Honor, before we call the next witness, we have some legal housekeeping matters regarding the next witness.
Okay. Will 10 minutes do it?
I think so.
I hope so. Ladies and gentlemen, I'm going to let you take a short recess. Please remember my instructions during the recess, and we'll call you back pretty quickly. Thank you. Okay, so what do we got? Stuff on Dr. Bedard?
Yes, judges. The next witness is Dr. Bedard. I know that certainly we had a Daubert hearing. The ruling was that he could testify.
Speak up a little, please.
Shut the door.
Yeah.
We had a Daubert ruling. Certainly the ruling was that Mr. Bedard, Dr. Bedard, would be able to testify as to his expertise in the field of defense tactics, use of force, and human factors. And I know the order says something to the effect of subject to the normal rules of evidence, so I know that the state approached me with some concerns. One of the concerns was because, you know, the deposition...
Let's be quiet in the galley, please. We're trying to hear.
The deposition was very wide-ranging, and I understand Mr. Martin's perspective. Dr. Bedard didn't write a report, so he just wanted to find out what his knowledge of is, and then potentially what he would be testifying to. And so one of the issues was a kind of a narration of the video. We agree that Dr. Bedard is not going to narrate the video in any form.
Okay.
Another issue, as I understand it, was that there was some discussion as to whether Dr. Bedard thought that Curtis Reeves acted reasonably. He gave his opinion because he was asked. I think he prefaced it with something to the effect of, I can't say that in front of a jury. Certainly, that's not going to be brought out in his testimony. One of the issues is I think it's an objection as to cumulativeness, because we had Dr. Cohen testify as to age-related kind of self-efficacy.
Mm-hmm.
You know, a person realizes they're vulnerable and all that. And so I know that that's something that one of the things Mr. Martin wants to address. So the court knows what my perspective is. It's true Dr. Cohen did testify to a limited degree about a perception of vulnerability. However, we stopped short of allowing her to do a threat assessment. In fact, that was one of the things that was objected to. So when it came down to making certain choices of doing things because of that perception of vulnerability, she wasn't allowed to do that. So it's not cumulative in that Dr. Bedard's going to testify that that's a factor in terms of threat assessment and risk assessment, which Dr. Cohen was not able to testify to.
Okay.
Judge Lewis's order, as you know, indicates as to whether any specific facts or data underlying Dr. Bedard's opinion or any specific testimony will be admissible at the trial will be a decision for the court at the time of trial and subject to any objections on that ground. So I have numerous objections to numerous parts of his testimony, and it includes not only what I presented in my previous motions that have been thoroughly briefed and you've had a benefit to read, but also statements that he made in the very lengthy deposition. So I'm going to begin with the issues that I brought forth in the motions that I'll file.
Okay.
And if we could just be able to address one at a time.
Yes, one at a time.
Mr. Martin has.
Yes.
Looks like many.
Yeah. Okay. One at a time.
Judge, one of the things that has always been a concern is the use of the video by experts. When an expert testifies, even though there's a jury instruction regarding the jury can accept or reject any testimony, including the expert. Anytime a person comes in and says, I know more than you because I have specialized knowledge, it carries some weight, and some people go, okay, I give up, I'm just going to go with he says. So it's important that I ferret out exactly where we're going with the expert testimony. I'm going to deal with the use of the video to start with. I understand that there's not going to be a running narrative of the video. But this is how the video was used by Dr. Bedard. He used the video to interpret, he used the content of the video in making certain interpretations. One, he used the video solely for his conclusions regarding certain points of interest. You might recall I listed out about 6 points of interest, and they included whether or not Mr. Reeves was hit with an object before the tossing of the popcorn, the relationship between the parties, the number of attacks, whether or not Mrs. Oulson was holding him back, was Mr. Oulson leaning or standing over, and whether or not Mr. Reeves uttered the words, throw popcorn. All of those points of interest were his analysis of that was solely based on the video. So when we start talking about, well, I determined this or I determined that, he could be interpreting the video, and there's no way around it. So my objection is that those points of interest, that's for the jury to decide based on the video. He can't come in and say, okay, my review of the video, Mrs. Oulson was or was not holding her husband back. See what I'm saying? So if he comes in and goes through those points of interest, relying solely on the video, well, that's for the jury to make the interpretation, not for the expert. You can understand the weight that was carried, and that's the problem that we have. So that was the thing with the video, not the running narrative. But if that in fact is proper, or he does that analysis based solely on the video, then that's for their determination.
And that's not a problem, Your Honor. Our intent is not to have Dr. Bedard comment on what he saw in the video or make any kind of conclusion, based on the video except for one. The only issue is going to be there is he's going to testify as to perception reaction time. And so the issue is going to be just the timing of the video. And I spoke to Mr. Martin, he's not opposed to this. The question will be not, did he watch how long and all this stuff. I can give him time references and say between this time and this time was the firing of the firearm in response to the throwing of popcorn. And I think that Mr. Martin agreed with me on that yesterday. And that's the extent of his use of the video in terms of being able to testify to that. And that's all we're looking to use it for. Not that, I saw, from my view, I saw Mr. Oulson coming across the seat at 13:25:36. That we've shown that video. Mm-hmm. We put photographs in. And the court has seen it as well. The first attack. He's not going to say there were 2 attacks and all that. If he's pushed, if somebody's going to ask him, well, how'd you come up with this or that? Then they're opening the door for him to say that. But I'm not eliciting that. That's not my purpose in having him testify.
What about that portion? I remember that portion pretty clearly, that, the breakdown of how many seconds it takes to do this, or milliseconds, and
Yeah, we've had that testimony.
not here in the trial yet, have we? Where was I if that?
No, we have not. And so to keep him from going as...
That witness did it last time. Yeah, at the previous hearing. You're right.
Oh,
You're
okay.
Right. It wasn't offered.
Okay.
So in terms of having...
Look, that's alluded. I can handle that on cross.
Okay, so that part is okay.
I can handle that.
The frames from the popcorn toss to the shoot is what he's going to talk about, the timing.
The whole grabbing, all that.
Right.
And Mr. Martin has agreed that I can lead him to get him through that, so that we're giving him points of reference.
Okay, so
he
we don't
doesn't
go
run
beyond
astray
that.
of That's
Okay,
right.
okay.
That's all we're looking to do.
Right.
Okay, so that one's all right. So Dr. Bedard is not going to interpret the video.
Right, it's not gonna be like one of those civil police shooting cases where he's gonna say, I looked at the video and I saw this force being applied, or that sort of thing that you typically see in civil cases. That's not
Right,
what's-
I've read some of his,
And frankly, if you ask him the question, he would refuse to do it because he understands it's the province of the jury in a criminal case, so he's not gonna do it.
okay. Go ahead.
The other issue was that based on his examination of the video, there's missing frames. There is no expertise on that. We've already had the testimony of experts, and so even if you would agree that he has the expertise to make that determination, it's cumulative. So I would object to that, and that was in his second deposition.
What about that?
Well, because I think the context of that again was, you have one attack 12 seconds before the popcorn attack, or what turns out to be a popcorn attack. And so, his hypothesis was potentially, well, I don't know what's happening there. Maybe the camera's not capturing something, but we know that maybe it is or maybe it isn't, because I heard that testimony. He's not going to testify in terms of what if that could be happening and this could be happening. You know what I mean? So the only time that would come up, the state asked him, well, you see nothing happening before that. It's just a popcorn. They're not going to ask that question. So I'm not. I know.
All
So
right.
I'm not going to ask him, about missing frames. And we've seen that there are parts of what happened missing because of the inadequacies and the temperament of the cameras and how they were set.
Okay,
So that's not a problem.
all
He
right.
also indicated in his second deposition that he has watched the video, and his interpretation of the video would be most consistent with what story Reeves has been telling. So to compare that to his statement in any way.
Right, I
find
remember that.
objectionable.
That's not a problem. He answered the question that he was asked, it was elicited of him, and again, I'm not faulting the prosecutor. He's, in his words, bobbing for apples, I get all that, but that's not the intention, that's not proper. Dr. Bedard isn't gonna testify to that, and again, because of his integrity, he wouldn't if you wanted him to,
Okay,
so that's not coming in.
all right, so that's not coming in.
He also speculated and interpreted what he did not see in the depot. And as an example, in the following the first deposition, I learned that there's a lot we can't see, so it's hard to validate what Mr. Reeves says or invalidate it. He also says Oulson standing up and striking Reeves with something, perhaps a fist with a phone. We can't see any of that. And then at the previous hearing, Reeves testified to a segment of what I've heard. He says, I don't see that. So when we're looking at what Mr. Reeves said previously at previous hearings, and then on the video, he's commenting, interpreting, and either giving credibility or not credibility. So that's just improper for him to interpret the video and then say, well, I can either confirm or deny Mr. Reeves' statement. So I object to that.
And again, Judge,
He did a lot of that, as I recall. That was his method of validating things and,
Yeah, the null hypothesis.
Thank you.
Because those questions were asked of him. I know you were on a red, maybe,
I
there were
did.
hours and hours of deposition.
I did. I read
And-
hours and hours of stuff.
I know. And so, Mr. Martin is very good at asking questions, there's various ways of asking the questions. So it became a philosophy, almost a philosophical discussion between Dr. Bedard and Mr. Martin. And so he said those things, but again, it's not our intent to present him to say that he finds Curtis Reeves credible, or that he finds him credible because he can see it on the video. That's,
Okay.
that's obviously not for him to testify to. That's for the jury to
Okay.
look at and decide. So
All right,
he's not going to do that.
That's, because that sort of dialogue did concern me as well, him commenting about Mr. Reeves, basically, in a nutshell, about Mr. Reeves' credibility.
And I understand.
And there was a lot of that.
And I wish the rules of evidence allowed me to do that, but I know they don't, Judge. He's not going to testify.
Okay.
Judge, the last thing regarding the video is this 6 to 8 second gap that you've heard that term used, throughout the trial so far. And what I'm objecting to is, again, he's commenting on what's not in the video. And this is the way he does it. and this is in the deposition, I don't think so. I would have, again, some of what's missing is the initial attack that Mr. Reeves described. That would have been a point of interest. It's still a point of interest, but it seems to be not captured. So again, he's going back and giving credibility to Mr. Reeves that 8-second gap, giving credibility and saying, yeah, I believe Reeves, what's that? So again, it goes to the credibility, and so I would object to that. It goes on, it's just a personal opinion about all the things that may or may not occur, but that's the most important thing because he specifically says, I believe Mr. Reeves.
And again, Judge, we're back to the missing frame things. I have my hypotheses of what occurred during those missing frames as well, but I know that certainly, if I were to testify, I couldn't do it, and I don't think that Dr. Bedard intends to do that. He's not going to talk about the missing frames. He's not going to hypothesize on what may or may not have occurred, or that he expected something to occur or not to have occurred during that time frame. So that's not a bone of contention here.
All right, so let me just clarify real quick about these missing frames. Are we talking about the blue and the black?
Yes, Your
The
Honor.
unrecorded.
Unrecorded
Right.
because there was no detection of movement.
Or because the sensors were set the camera was pointed in such a way as not to detect movement. There are several reasons given as to why that.
But there's all of
Sensitivity,
which
all
are basically because it wasn't the greatest system in a short way
The
of saying
system
it.
worked as it was designed.
But there's no indication that somehow, as I didn't hear anything from the expert witness about the missing frames. It's not like somebody came and altered it.
It was an unartful way for me to make that statement. I should have said the unrecorded.
Okay,
Right,
my fault.
thank you.
Right, and the expert explained that it's because of the sensitivity, the settings of the camera. The expert also testified, well, we'll never know what those are because we never got the hardware and all of that. But, that's what we're talking about.
Okay.
Those unrecorded frames, I think.
Okay,
the court's correct
unrecorded
in
moments.
Judge, the next one is a little more complex
Okay,
because we're dealing with this self-report method to apprise coping, self-efficacy. It's along the same lines as Dr. Cohen testified to. She even testified that individuals will in fact make decisions based on what they know their limitations were, whether it be mental skills, physical skills. That's the way we go through life, and as we age, those parameters may differ, but our decisions are based on what we know about ourselves. So when we talk about self-efficacy, which is what Dr. Bedard wants to testify about, he read my section in Daubert about that and all the literature. Okay, I don't need to go into that, but here's the main point. First is cumulative to Dr. Cohen. Second is that in order for that to be admissible with an expert under 702, it has to be helpful to the juror. And this is what Dr. Bedard said in the second deposition on pages 28 through 30. Do you agree or disagree that it is common knowledge among adults, if you will, who have certain life experiences, that in making a decision that they will weigh their individual limitations in making the decision on how to complete a specific task? That's pretty common knowledge to everyone, isn't it? Yes, I think so. So we have a situation where we're putting on an expert who has acknowledged that he candidly says, yeah, that's basically everybody knows that. So that would be the cumulative would be the first one. Second, he's already acknowledged that it would not aid the jury. And then I'll get you the right page. We talk about the self-efficacy, he identified certain things, that Mr. Reeves knows. But again, he acknowledges, just like he did when we had a brief discussion about it, that this is all common knowledge. It's when you make a decision, we take it in our limitations. So I would suggest to the court that we not only have a cumulative argument, but we also have, as an expert, designate the jury. So I would suggest to the court that you consider that, and whether or not he's going to go into this litany discussion about self-efficacy and decision-making process, go on and on, when we've already had one expert very succinctly say, yeah, that's the way it is, and now we're going to do it again? No, that's just cumulative, and he already admits, everybody knows it.
All right. I remember much of Dr. Bedard's testimony about this, and there was definitely separate, over and above, if you will, beyond what Dr. Cohen testified, more in the context of combat almost. Can I take him, or should I take him, or am I able to take him, or something along those lines. So what about that? What about Mr. Martin's objection?
Well, number one, in terms of cumulative, it's not cumulative because it's definitely in a different context. And certainly, Dr. Cohen was brought up short of being able to put it into context. In terms of the objection, sounds like a Dauber-like objection that it wouldn't aid the jury because the person in question saying that that's pretty common to everyone. But again, it's within context. We all know probably that if it's dark, it's more dangerous. We all know that if it's loud, we can't hear as well. If it's dark, we can't see as well. But what we don't understand is that put together, these factors can have different meaning to somebody who is trained properly. And that's where the whole risk assessment thing comes in, right? You have the threat assessment, so you identify the threat. Risk assessment dealing with human factors, and this is one of those human factors. So really it goes more to weight than admissibility, because really that's what we're talking about in Dauber. This isn't something that's so far within the realm of common knowledge. I mean, Dr. Bedard, I don't know what he thinks about the common person. What we tend to do in this profession as well, we tend to think that people know what we consider very simplistic ideas in our profession. For instance, objections. I see lawyers do it all the time. They'll come into court and they'll speak to prospective jurors as if they know what we're talking about. Some of them do, that's true, but not everyone. So just because his opinion at that time was, well, it's pretty common knowledge, we have to look at it in context. So I don't think, it's definitely not cumulative, it's in a different context. And secondly, it will aid the jury in understanding the concept, the human concept, human factors concept of risk assessment.
All right, so what you're saying is that you want him to testify about threat assessment and risk assessment in the context of someone who's been trained?
Yes, Your Honor.
All right, and
that's not this issue. I mean, I'm not talking about training, I'm talking about physical limitations and
okay, but in the context of someone who has this training, that's what I'm getting at.
I'm sorry.
Because if not, then I tend to agree to some point that it is common knowledge. So, in other words, what I'm hoping to avoid is that you're not going to just regurgitate or have him repeat everything that Dr. Cohen indicated.
If I could address that, Your Honor?
Yes?
There's no amount of training that can change the infirmities that come with age. So it doesn't relate to training. It has nothing to do with training. We're going to get to this point in our lives and we make decisions based on where we are. That's not any type of professional training. It's Apples and oranges.
Well, I'm speaking about what I've gleaned from Dr. Bedard's testimony, that's what he's indicating, that because of his training, he's going to react this way, or a police officer would react this way.
I think that's threat assessment. That's another area.
Well,
No, this is more, well, they kind of bleed over into each other. Threat assessment, you're looking at what's presented to you as a threat. Risk assessment, you're making a decision based on, in this case, your own limitations, whether that be physical, whether it be psychological, and physical includes not only, being older, but not necessarily, that was Dr. Cohen's testimony. Physical assessment of oneself could be that I'm not that strong. I don't have to be 71 years old to know that, if I'm a 92-pound weakling, that I'm not going to be able to take somebody. So it doesn't necessarily have to do 100% with age. It has to do with size. There are a lot of different things. So, part of the training is you have to assess your situation, including your own limitations. So I think that, for that reason, put in context, the jury should be able to hear that. That's part of the program that's being taught by Dr. Bedard.
all right, so let's keep it from not being cumulative to Dr. Cohen. And
Well, we're not talking about, the aged in particular. We're just talking about physical limitation.
all right, and before you move on, Mr. Martin, before I forget, I remember multiple times an exchange between you and Dr. Bedard about what you would say, so you want to tell this jury this, and Dr. Bedard would say, I don't want to tell them anything. I'll say what I was asked. I'll answer what I was asked. Can we avoid that to some extent?
I don't know, because I don't know if I ever got to what he's going to be asked, because the analogy is I was bobbing for apples. I have no idea.
Well, just rephrase, is it your intention to testify if asked? Because it was clear to me what the dialogue and what the offense was in Dr. Bedard's eyes, that he took offense that you indicated he wanted to test, he wanted to tell the jury things. So
okay.
that I saw no less than 5 or 6 encounters like that in the reading, and we can't afford that type of banter. But I'm not trying to limit.
It was a depot, Your Honor.
I know, and I'm not trying to limit. Obviously, you have your strategy, and maybe that's part to raise the ire of the witness. I don't know, but let's try to not do it
I apologize.
multiple times.
I have no idea where the court's going with that. That's not going to come up in the courtroom. That's deposition. That's not proper cross. That's not any.
Right, because if he says something like that in the courtroom, he might not like the answer that
Yeah,
the witness gives him.
that.
So, if he
All
wants
right.
to say it, have at it.
Okay, maybe it was an artful way to try to figure out exactly what was going on, but that's not courtroom stuff.
All right, well, that's what, you want to tell the jury. You want to tell the jury. You want to tell the jury.
No, that's.
Okay, all right.
When
Okay, great. You need a break now?
we're done with this argument.
Okay, I'll give you a break for sure.
Judge, one of the things when we were talking about the talking points and that did not relate to the video was that Mr. Bedard did in fact interview Mr. Reeves. And I don't know if they're going to attempt to get in it. There's a whole different argument.
We're not, he's not talking about an interview with Mr. Reeves and his opinion based on that interview as to what occurred or didn't occur.
Okay,
This is not a forensic psychological examination of Mr.
Okay.
Reeves.
Okay, but one of the issues that came up that I'm concerned about, and I don't want to get blindsided on it without discussing to the court, is that for the first time, Mr. Reeves said, oh, by the way, I heard patrons in the theater say the words throw popcorn. The very first time that's ever come up. And so then Mr. Bedard goes through this litany of if he said that, and then he says basically, he goes into his reasoning about, well, that might make sense, that not make sense. See what I'm getting at? I don't, if we're not going to talk about anything about the devil, then this doesn't come in. If this is coming in, then we got a whole different argument. So I'm.
Are you talking about the part where he said, he comments on the statement you threw popcorn and how the timing of it?
No,
wouldn't-
Mr. Reeves says he heard patrons say that. He didn't say it. That's what he told the dog.
Okay.
That's the first time that's ever been said. So I want to know if that's an issue that they're going to bring up, because it is, and we have other arguments.
Sounds like hearsay to me, but I
Well, it does to me too.
didn't think of trying to get that in.
All right.
All right. Anything
I
else?
think it's a valid theory though, but I can't elicit it from Dr. Bedard.
Judge, there's the one about, he has a section of knowledge that we discussed dealing with people involved in a stressful situation, an artifact that may indicate and verify that the event was in fact stressful. You might recall that in the event. We talked about artifacts. Those artifacts being reaction time, different perceptions, cognitive perception differences, television. Remember, he had a list of all those things. Then what he says is, and I asked him, well, did you see any of that, Mr. Reeves? And very candidly, he said no. He said, I didn't see a lot of this. As a matter of fact, the only thing I saw was some memory issues. I think that demonstrates that at some level, fragment memory also occurs under high arousal. But he also says that that he did not see any of those except maybe fragment memory that went to in the law enforcement statement, I don't recall. If he didn't see any of that, that's what he testified at the depot, then it's not relevant. You just don't put something before the jury and say A, B, C, and D when it doesn't apply to the defendant. So if it's a non-issue, why would we go through and educate the jury on something that doesn't exist in the case? So it's not relevant, and I would ask that that be excluded, because Dr. Bard very candidly said, I didn't see any of that.
So I'm trying to wrap my head around this. On the one hand, the prosecutor said you can't use the interview because that's not legitimate to use in this sort of trial. It's not a forensic examination, my words, but we cannot use that interview. We can't say what Reeves said. Now they're saying, well, based on that interview, and again, we don't know how complete it was, we don't know exactly what questions were asked of Mr. Reeves, that somehow we're going to decide that these artifacts of stress, in other words, what happens when an individual is under stress, again, that Dr. Bedard not only trains others in, but has studied extensively, that he can't educate the jury on what these stressors are and what the manifestation of those stresses are. That makes absolutely no sense. The jury can decide if Mr. Reeves was under that stress or not, if he suffered some artifacts of stress, if they want, but certainly it's not irrelevant, it's relevant to the whole idea of human factors, the whole idea of risk assessment and making those choices. So, the jury can decide to apply or not. This would be different if the presentation was, these are the manifestations of stress, and these match up with ones that Reeves had or that he didn't have. We're not doing that. We're educating the jury on the use of force, the training of the use of force, and certain things that have been studied. And again, we're not going to cite studies. I know we can't cite studies, and in this individual's experience and his teaching that describe kind of the human condition under these situations. And I don't think that's out of bounds at all, especially since we can't say, well, Reeves didn't say this in his interview with Dr. Bedard, and so therefore it's irrelevant.
Okay, maybe I didn't artfully say that either. Dr. Bedard looked at the law enforcement statement, and the prior hearing testimony. All right? He also talked to him, that's true, but in using all of those, he did not find any of those artifacts. And if we go to the deposition that was taken on November 19th, it's basically page 101 through 104, where it's kind of lengthy. When I asked on page 103, okay, I want to turn to the residual effects that we've been talking about. And then on page 104, so the artifacts, when I usually look for them, and let me preface my answer by saying I didn't find a whole lot of artifacts. I guess I was surprised. And I think, partly I think during the deposition why I wanted to interview, and that's when he talked about that. He said, here's the problem with Reeves, and I can tell you, see, he knows all of these things. And I mean, if he wanted to fake it, he's aware of tunnel vision, he's aware of auditory exclusion, he's aware of, I can't pronounce those, vast audulation and vast constriction. So he basically said, I didn't see any of it.
Well,
He never either in the law enforcement interview or at the previous immunity or anywhere did he say anything that would suggest that he had tunnel vision or narrowing reaction. So if he's done it, he's said everything, he talked to Reeves, looked at everything, and said, I don't see anything, except for the fragmented memory. And so it's not relevant.
And I don't know that if this prosecutor misspoke or not, but when he quoted the deposition, he said that what Dr. Bernard told him was, I don't see a whole lot of artifacts. In other words, he's not saying I didn't see any that was presented to the court. And frankly, if he's going by that interview, well, we know about the interview by now. It wasn't the greatest interview in the world. Probably Dr. Bernard, if he's asked, would tell you that when an officer is involved in a shooting, usually they wait a day because of these issues. So, you know, I don't see where the prosecutor's coming from in terms of not being able to at least
All right,
discuss stress.
from what I'm hearing, I'm going to overrule as to the artifacts of stress. Okay. We need to wrap this up.
Okay, so now we get to what I've been marching up and down, wearing out the carpet about. It's how we treat Mr. Reeves as, and dealing with the issues and decision-making. Is he a law enforcement officer or is he a civilian? And we're going to have the testimony from Dr. Bernard indicating that as a law enforcement instructor, he's aware of how law enforcement is taught. He's aware of the teaching tool known as a force matrix model or force continuum. And I know that might be a foreign concept to you, so may I approach, and I'll show counsel what I'm going to hand you. Because I think it's helpful.
And we can do this real quick.
Can I approach?
Mm-hmm.
Judge, there was a time when these type of models were prevalent in the agency's policy. I've had this discussion with Mr. Bernard, so I'm kind of parroting what he told me to. It's no longer in the basic recruit manual as of 2007, I believe is what he said. But they were used as a teaching aid. The court recalls that since 1989, law enforcement's use of force has been governed under the Fourth Amendment, under constitutional law. And so someone came up with an idea of how we're going to try to explain these concepts to law enforcement. Now we use simulators, we do a lot of other things, but back then, this is what came out. So what he has done, since when he teaches civilians to help them understand certain parameters to give guidance, drawing the line in the sand, when you're going to shoot or not shoot. He uses these models as an example. Look, if A happens, you can respond this way. And you might be in pretty good shape. If B happens, you can respond this way. You'd probably be in pretty good. It's just a tool visually to help understand, so people in their own minds can draw the line in the sand when they are or not going to use a particular type of force. It is not appropriate to use it to educate the jury. And the reason for that is the way he explains it is that the reasonableness of the action is linear. And you go straight across or up or down, whatever, and if you do A and B, that's reasonable. That's what he's going to tell the jury. And that is not the case. And you recall in my discussions in the pleading, we talked about, even in Graham, where objective reasonableness is, you can't decide it in a mechanical way. And that's exactly what this attempts to do. And you can understand what agencies would do it. All right, they want to hold accountability somewhere for the officers or whatever, but that's not the court of law. Our jury instruction will be given 3.6 paren F. You're going to give that to them, and in no way does that concept apply. It's the reasonable man standard. You just don't go, put pigeonhole it here, therefore this is it, and then you don't have to think about it. And that's where we get into the misleading part, when he starts talking about force continuums and matrix, because that's how he explains what is, and I know we're not going to talk about reasonable, but I don't know what's going to, his testimony is going to be. So I don't know what's going to, just like we've had some things come up that we didn't want. I have no idea. So I need to bring this to the court's attention that I object to his any explanation whatsoever as to what's reasonable, how to determine what is something reasonable. He can go, look, these are factors for threat assessment, this is factors for situational awareness, here's all the information is, here's the facts, or whatever, but we don't pigeonhole it with this force matrix and continuum, because that's the way he likes to explain his testimony. So, Mr. Reeves isn't a police officer, he's not on duty. This isn't like the officer Potter with the taser and the gun. We're not in that situation. We have a civilian here. That doesn't apply. Of course, the Fourth Amendment doesn't apply to Mr. Reeves. We're nowhere near that. So all of this would just be totally confusing to the jury when they get your final instruction. So I object to that as being how he explains how one decides how to respond to a certain response. Because if we look on his second deposition on pages 553 to 554, I assume about the subjectivity of it, and of course the one that can answer the question would be Reeves. I'm aware of what Reeves said, so taking Reeves as true, I would be able to comment on the subjectivity of it and put those behaviors of Mr. Oulson in categories of threat and show the straight line appropriate response. And that would be going back to the objectivity and hindsight. See what he wants to do? That is totally inappropriate. So I object to that.
Well, that's not what I want to do. Frankly, in terms of that portion of use of force from Dr. Bedard, it's going to be very similar to what the state elicited in the Draker trial. It's going to look a lot like that. There he drew what was essentially a force continuum on a piece of paper. He's going to probably do it on the whiteboard here. He didn't make any comments as to whether it was appropriate or not. And in fact, in this case, it's relevant because we got to remember that Curtis Reeves was a former police officer who was trained, so I think it's important that the jury understands his training in terms of talking about the Fourth Amendment or objective reasonableness or something. Those issues are not coming up. He's not here to tell the jury that's objectively reasonable under the standard for law enforcement. He's not going to say that it's subjectively unreasonable for Mr. Reeves because of his training in law enforcement. I mean, that's not going to happen. He wants to be able to explain, number one, that there's certain categories of use of force, and number two, that there's certain levels of use of force. That's what he wants to show this jury.
Judge, I'll let Mr. Rosenwasser address that issue.
Yeah, the only reason that we brought, I mean, obviously I prosecuted the Drake case. So the only reason we brought it up was in the defendant's interview, he was using those terms. He was the one, meaning Drake used the terms force continuum and force multiplier. So Dr. Bedard was brought in just to explain those terms so the jury understood what possibly the defendant was referring to. The chart that was drawn was only because that's what the defendant was referring to. Now in this case, you have the defendant, and the chart really wouldn't apply because if you're a police officer, you can one-up level to get compliance from someone, but a citizen can't do that. That's more law enforcement, which is then when you get the bleeding that Mr. Martin's been talking about, that we can't put Mr. Reeves in the position of a law enforcement officer that can, because a law enforcement officer can draw someone down at gunpoint. Now, obviously, if a citizen does that, that's an aggravated assault. So you can't mix and match those two things because the defendant's not a police officer in this case, he's just a regular citizen, so that chart wouldn't apply in this case.
It's to show the jury, to get an idea of Mr. Reeves' training. And one of the issues we have here, frankly, Mr. Reeves was never asked. So let's say, using the state's example, let's say the detective questioned Mr. Reeves as to his knowledge of the force continuum. And then he says, yes, I'm aware of the force continuum. So now we get to use the expert because Mr. Reeves used those magic words to show that he either did or didn't know what the use. No, that doesn't make any sense. And I appreciate that the prosecutor is, it's creative to say that, we're using it just to define these terms, but the court may have seen the testimony of Dr. Bedard or may not have. But frankly, he wasn't just up there to say, no, that's not what force continuum means. He got up there and drew a chart to show exactly what it meant. So it had a dual kind of effect on the jury, I'm sure, but we're doing it strictly for the purpose of educating the jury as to what law enforcement is taught by Dr. Roy Bedard, who is a police trainer.
Why does it matter what he's taught? Because you can't use that chart in civilian life. I mean, I don't disagree with the fact that they can say he's got law enforcement experience. But that and this issue are completely different.
Well, can't that be brought out on cross as opposed to excluding it altogether?
I mean, the reason that I would say not is because it really is, like, we all understand this because this is what we do for a living. I think for a lay person to understand that is going to be very difficult. And, for that reason, it really would be confusing. They don't understand force continuum, the chart, the difference between what police can do and what citizens can do. And we don't really need that mixing and matching because he's a civilian in a civilian case.
So if I understand that argument, it's confusing to give the jury information. It's not confusing. It's somehow more enlightening to tell the jury in this vacuum that Mr. Reeves was trained for all these years as a police officer, and although he's not being judged by the standards of a police officer, we can all agree that certainly part of his belief as he was, and I know that the court heard a million times, standing in the shoes and sitting in the seat, but it's true. And so, that's why this is necessary, just to give them a glimpse of the, you can't just say, well, this person was a professional dressage jumper. Well, they may or may not even know what dressage jumper is, and certainly they might not know what it feels like to be on the back of a horse or to get the physical training or anything like that. So I just don't see how we cannot tell the jury about Mr. Reeves' education and give them a glimpse of what it is. We're not saying this means that Mr. Reeves acted. That's for argument. They can argue, and certainly they can cross-examine, as the court suggested. This is about gatekeeping, and certainly he's going to be there for cross-examination. If they have a problem with that, they can go after Dr. Bedard and say, hey, what you showed applies to police officers only, doesn't apply to civilians. Let's see how he answers it.
Well, I know it's going to answer because civilians don't have a model. I adapt it and I tell civilians this is what the law is. That's what he's going to say, because I've asked him in the depo, and I don't want that in front of the jury. So am I going to ask that question? No. So here's the problem, Judge. We're not saying he can't say, I know behavioral cues, I know reaction time, I know to keep my distance, I know. He can say all of those things, but when you take all those factors and then pigeonhole it in a chart and have him say straight line across, that's where the problem is. I'm not trying to prevent them from saying he doesn't know how to judge whether or not something is a threat based on his training. It's the chart that says if you do this and this, it is okay. That's where I have the problem. That's why the chart doesn't come in. That's why there's no mention whatsoever of force matrix model or force continuum. They can talk all they want about all his behavior cues and how he knows when there's threat and all the things they look for. You just can't put it out there and say linear across, this is okay, because that's for the jury to decide.
I don't think he says that it's okay in a linear fashion. He says this is what you're presented with. These
All
are
right,
the decisions.
what's the relevance of the use of force continuum?
To show Mr. Reeves' education and part of his training.
And the matrix?
And just a way to explain it in a visual way to the jury that there are different categories of use of force and that there are different levels of use of force. I mean, that's essentially what it's being used for.
How is that relevant?
See, there is no national standard for civilians. So he is a civilian. So this is based on Fourth Amendment considerations. And contrary to what Mr. Michael says, clearly he said, Mr. Oulson, I would be able to put Mr. Oulson in categories of threat, different levels on the same, and show the straight line appropriate response. That is just totally wrong.
He's not asking to do that. We're not asking him to do that.
I agree, that's not proper. So, I'm gonna agree with State on that.
So tell me then what he can do. Certainly consider different levels of force.
I knew you were gonna ask that.
Well, I don't want them jumping up. I've
All right,
only been able to
so-
say 3 words in 3 weeks here without them jumping up.
There is no level of force that are, quote, standardized for civilians. Therein lies the problem. What is unique between the law enforcement officers are the cues. How, if you look and saw A, B, and C in a person, posturing, leaning forward, aggressive, those are all common between civilian and law enforcement. They can go into all of that, that's fine. As far if you're going to take, if you look at, say, A, B, and C, then maybe you'd be aware and it would heighten your awareness and you would want to be more cautious. That's fine, but to say, okay, based on his training, he got this, and I'll call it archaic because it's not taught anymore, and it doesn't apply to civilians, and there's no national standard for civilians, then that's inappropriate because that's what he wants to do, straight lines. All the behavior cues are consistent.
Right, okay.
No straight line.
Right, so my question is, the court ruled no straight line. So I'm saying, can I say, are there various categories of use of force? Are there very levels? He won't draw a chart if that's what they don't want him to do, and he'll just say that, and we'll go into the cues and all those other things they talk about.
How is that relevant? Because you're going to go through the different levels. Okay, yeah, if I'm just mouthing off, it's non-aggressive. Okay, non-aggressive, then you can use a pepper spray. See where I'm going? The levels, no. We're getting back into the same thing. We're just orally describing the force matrix. The civilians have no levels. It's either reasonable or it's not reasonable based on their subjective perception of what they saw, period.
Of reasonableness of which civilian? A civilian who has no police training, or a civilian who is extensively trained in the police department? That's
All right, so there's got to be a happy medium here.
I'm sorry.
Go ahead.
Sorry. As of right now, we don't have really any evidence of his extensive training. The only evidence is in his tape statement. He just says he retired from the police department. There is no evidence, because the defendant hasn't testified, about some extensive amount of training. Zero.
Well, Your Honor, I think the court may remember there was a big motion regarding all the certificates and all of Mr. Reeves's achievements. So I think the court is well aware of his extensive training going all the way back to the late 60s. And so I don't know that.
I don't know that's in evidence. In fact, I know the
Okay,
answer, it's not in evidence.
You're absolutely correct. As we sit here right now in this trial, there is no evidence. That's correct.
Well, that sounds like an issue for later on, either argument that the evidence didn't come out, or to question Bedard about what he knows.
Okay, so I'm going to glaze over that right now. The happy medium that I'm talking about is I believe that the defense is able to elicit testimony regarding how, police training. But that's about it. That he can't project that over to Mr. Reeves and how he acted and why.
He's not going to. We just want to know the training. So is the court all right with me saying, we're going to hear about his extensive training of police forces from United Emirates all the way to Barbados and everywhere in between. And so I can ask him if he trains these police forces and various security forces in the field of use of force, right? I can do that. And he's going to say yes, right?
Is that to imply that because Curtis Reeves is a police officer, where Bedard trained him? I mean...
That's silly, but anyway, Judge.
Well, right, but I'm saying, what was the point of what you just said?
Because he trains police officers.
Well,
Mr. Reeves is a 27-year police veteran. That's going to come out. The court can be assured. If it doesn't come out, then guess what? Now they have something to argue in closing. Why did they put this guy up here? He doesn't have anything to do with it. The same thing I argued in terms of opening. I shouldn't have argued, but I did argue a bit in opening in terms of, the prosecutor's opening statement. So, I mean...
It's funny because I brought it out, and then I'm trying not to make it personal, but Mr. Michaels then said that was silly, but he actually agreed that's what the argument was he was making. Bedard does all this training, Curtis Reeves is a police officer, they're trying to overlap the circles that now we know what kind of training Curtis Reeves has. We don't. There's no testimony or evidence at all, other than the fact he's retired police. That is completely all the evidence right now.
Experts make opinions over information they're given every single day of the week. We had Dr. Foley in here earlier today giving his opinion over some x-rays that were presented to him. There was no evidence presented prior to this that he had arthritic knees or anything else. That evidence came in because that's an expert's opinion. So I don't see how. So now we're going to exclude. It sounds like what they're saying is we're going to exclude Dr. Bedard now, even though we have a court ruling that he can testify subject to evidentiary issues.
Judge, on this issue, I did discuss it with him, and he said, basically, I'll paraphrase a little bit, Bernard admits he does not know the law enforcement curriculum Reeves received at the Tampa Police Department. That's the first deposition, page 133, lines 18 through 20. Specifically, he does not know the curriculum Reeves received involving use of force or threat analysis. The first deposition, page 133, line 21 through 25. Bernard acknowledges in the 1970s, when Reeves received his law enforcement training, a standard curriculum was only in the developmental stage, and academies were free to develop their own curriculum. That's the first deposition, page 134, line 1 through 9. Bernard finally admits he does not know the specifics of Reeves' law enforcement training. Again, the first deposition, page 134, lines 15 through 19. In response to not knowing the specific of Reeves' training, he stated if Reeves was an instructor, he would know the material. But again, he doesn't know the curriculum of what that was. He candidly testified, I have no idea. So what he's saying is, okay, I have no idea what he was taught. And back then, there was no curriculum. Tampa PD, they had their own academies back in the 70s. St. Pete PD and the agencies here were at the Votech Center down in Pinellas County. So everyone had their own thing going. They could write whatever they want. So there's no way that Bernard knows exactly what training he received because nothing was standardized, not until later on when we finally get FBLE involved and they write the curriculum. He admits he does not know the training of Mr. Reeves.
Which is wonderful for cross-examination, but not a legal reason to exclude this testimony. I have a good faith basis to ask Dr. Bedard, and he has a reason for his testimony, and so the state can certainly cross-examine him about that, and that's kind of where we're at. It's not a reason to exclude the evidence.
The good faith basis is the deposition where he says he didn't know?
The good faith basis, frankly, Your Honor, is knowing that my client has served 27 years at Tampa Police Department, that he's had training from the very beginning, that he's trained other officers, that he started the SWAT department, that he has extensive training in the use of force. He's trained men in the use of force. So that's my good faith basis, Your Honor.
If he testified and all that came out, maybe it's a different story.
That's
I don't know.
different than good faith basis. He knows
I mean,
that.
but there is none. I mean, there's no good faith basis. His good faith basis is because they know Curtis Reeves and they know his background. That's good faith. The witness doesn't know it.
Again, that's
That's a story.
cross-examination.
It's not cross-examination because he doesn't know it. I mean, I can't put it any simpler than that. He just doesn't know it. There's no foundation.
Back then, when he was doing all that, there was no standard curriculum. Tampa PD could do whatever.
So what are you
they want.
arguing now?
Huh?
What are you arguing now, that he can't testify at all?
No, he just can't testify to his police training because he doesn't know it.
He's
It
not
went
gonna-
back. It went back to that. We were talking about how the
matrix and
matrix,
everything.
and then they said, "Oh, I just won't draw the matrix," and we're like, "No, it's all about the whole concept of the matrix," and that's how we went to. He should be able to testify to the matrix because he is a trained law enforcement officer, and then we segued into there is no testimony about his training, and that Bedard doesn't know it at all.
That's something, I don't know where they got that from, and I'm sure the
All
court
right.
feels like I do, I'm busy. I just said that Bedard's gonna testify that he trains police officers in the subject of use of force. Right? He's not gonna draw a matrix. So that's how this whole thing started. I think that he can testify to that.
All right, the matrix is definitely not appropriate, I think. No chart.
No levels. I mean, we're getting visualization of the chart.
Yeah, the levels are, with the argument that I've got before me, I think the levels are not appropriate either in light of the fact that it appears from prior testimony that Dr. Bedard is not aware of what Mr. Reeves' training is, or that in the years that Mr. Reeves was trained, this wasn't applicable. So I think it's irrelevant.
Well, can I have Dr. Bedard interview Mr. Reeves right now, if you give us a 10-minute recess so that he has that knowledge, Your Honor? Because frankly, I mean, I don't understand the state's argument. I don't understand it.
Well, how does that solve the situation? I mean, it still doesn't reverse your rulings at all as far as orally talking about levels and responses and matrix. It doesn't matter.
It's really
Yeah.
just backdooring the defendant's testimony.
What I'm looking at in this chart is stuff that, if this is what Mr. Reeves taught and used every day, might have some relevance. However, the relevance is tempered with the fact that he retired 20 years ago, plus. So, but the fact that we don't know that he was trained in this and that he used this and this is like riding a bike to him, then I don't see the relevance. So.
Then I can ask this, Your Honor. You know, I know, that he trains police agencies, police officers in the use of force, right? That Roy Bedard does.
Mhm.
And part of his training involves something called a force matrix, a force continuum? And he says yes, and then I move on and we talk about other things. Just so later on, should we have the testimony to back that up, now we can link it up, and at least we've had Dr. Bedard say, yes, he teaches that.
We're back to, it doesn't apply to civilians. This is a tool to teach law enforcement.
All right, I got that. That can come out in cross. I'm going to allow that limited area of questioning regarding the continuum and the matrix under the circumstances. And then you can ask, clearly that doesn't apply to civilians. So I'm done. We're done. We're done talking about this. It's been over an hour, and we're getting nowhere fast. So that's that. All right. Done, right? We're done, that's it?
You told me I was done. I'm not saying that.
What else do you have, Mr. Martin? What other objections?
Not objections. I know what his response is going to be. He goes, yeah, it does, because there's no standard model for civilians, so we use this. So I'm not going to be able to ask that question. I'm not answering that question.
All right,
So
then that's fine.
That's his answer.
Okay,
So
okay.
it's just not helpful.
I think the court's asking if Mr. Martin has any further objections other than the ones we've already spoken about. Do I have that right?
Correct. All right, then let's take 10 minutes ourselves quickly, a fast 10 minutes.
Well, Judge, after these rulings, I need some time to
I know.
sit down with Dr. Bedard. I don't want, something to happen that shouldn't happen.
Well, don't sit down, just stand and tell me. How about that? Let's get that straight. And obviously, we're not going to finish with Dr. Bedard today, but we're certainly not quitting at 4 o'clock.
Judge, can I, on another note, just real quickly introduce the actual pictures that from the thumb drive. Remember, I told you I would introduce the
Yes.
thumb drive,
Yes,
and so this is just VB1.
okay. Good enough.
That's an easy one.
That's an easy one. All right.
VB1.